joined us today for our conversation today with Richard Hornsby. Welcome, Richard.
Hi, Joy. Thanks for having me.
Yeah, and so we're going to talk today about the Zimmerman case. Both Richard and I have done commentary for some of the news stations, but in those situations, I'm always frustrated by the fact that we only get to talk in like 2-minute intervals.
Sounds like.
So we're going to sort of talk through it and go through it a little bit more today. Sound good?
I look forward to it.
Okay. So let's talk about first sort of the bulk of the evidence in this case.
Statements. He did things I would never imagine someone would do, like scream at the top of his lungs to get voice samples.
Here we don't have, like a lot of cases, sort of a whodunit kind of thing. We clearly know that there's, a dead body, and we clearly know who did it.
Yeah.
So what's the other foundation of the evidence in this case?
Well, the majority of the evidence obviously is from George Zimmerman himself. He gave all those different, and then I think the other evidence. There's two other aspects of the case. There's witness 8, who we know is called Dee Dee, who's Trayvon's girlfriend. She's going to be allowed to testify to anything that Trayvon was telling her as it was happening, because it's an exception to the hearsay rule. And that seems to be very incriminating against George Zimmerman. And then you have these other witnesses that they're kind of a hodgepodge of different witnesses that saw different things right as they were happening during the altercation.
I don't think my neighbor's lights were on because I couldn't see the figures. That's why I couldn't make them out. At the same time I was looking out, then my neighbor, he came out at the same time and he was like, "Yo, what's going on out there? What's going on out there?"
What neighbor?
And I heard a noise. It was a screaming noise, and I thought it was kids playing in the back, because they normally do. And it sounded like somebody saying either no or something like, "Oh."
We went around the side, but they had already started roping off, and I think they were doing CPR, so we didn't want to get in anyone's business. But
I saw two shadows. Turned around, told my husband, and he went outside, and I looked out the window again, and I saw a man standing with a jacket talking to my husband. That's all.
The majority of them support George Zimmerman, but some of them have come out and changed their stories a little bit, because once they found, it seemed like they sided with Trayvon Martin once they heard a little bit about him, and they've changed their stories, but the bulk of the evidence seems to support the general proposition that George Zimmerman said in all these interviews he's given.
Yeah. Well, most of the witnesses, though, saw the altercation and aftermath.
Right.
We don't have any evidence, at least that I have seen, about what happened leading up to that, really. There was one witness who said that she saw two people running in the neighborhood, but it was from like upstairs without her contacts.
Right.
And I don't know.
She went back to cooking and it wasn't a big deal to her.
Right. Although it doesn't take great eyesight to see two figures running. I mean...
But the big question is, was it them? There was apparently some kid who was walking his dog at the same time. He was chasing after his dog, and so there's always these issues of what exactly did she see. It's kind of like my cousin Vinny. How many fingers do I have up to the lady without the glasses?
Right.
How much weight somebody's going to give that is up to a jury, and as me and you both know, jurors are probably a little bit skeptical of that once Mark O'Mara is done, cross-examining that person.
Yeah. Okay. So now, explain a little bit about what the girlfriend is going to testify to as far as what Trayvon was saying.
Apparently what Dee Dee is going to say is that Trayvon was expressing fear of George Zimmerman, that he felt like George Zimmerman was following him, which the state is going to try to portray as stalking or profiling or something like that. And, and Dee Dee makes it sound like, based on her last statements that she had with Trayvon Martin, is that it was actually George Zimmerman who kind of startled Trayvon and was like, "What are you doing here?" And that's like the last thing that Dee Dee hears. And, and that's kind of, that seems to be, I think, the hang up that everybody has with this case is, even if Trayvon Martin did swing on George Zimmerman, why did he confront Trayvon Martin? Why didn't he wait for the police? Why? It's, no matter how you want to couch it, the end of the day, I think everybody believes that George Zimmerman caused this whole incident, regardless of whether or not he was, legally justified or not.
Yeah, I think that is the state's best argument, and that is, listen, if he had stayed in the car, none of this would have happened. And he was instructed to stay in the car. And he chose not to, and as a result, Trayvon's dead.
And it's funny, if I wasn't a lawyer, I would think that was the greatest argument in the world too, but if I'm the defense, what I'm waiting for, Mark O'Mara and Don West to ask the judge to say is, Judge, they're not allowed to make that argument, because the bottom line is that there is no law that says it's you're not allowed to confront anybody in a neighborhood. You're not allowed to approach anybody. There's no law that says you have to listen. And he didn't call 911. He actually called the non-emergency number. They're not dispatched, and they never told him to not do anything. They said ambiguously, you don't have to do that.
It said, we need you not to do that. Zimmerman said, I'm following him, and the 911 officer said, or dispatcher said, I need you not to do that.
I thought, well, if that's the case, it's a little bit different semantically. I thought he said you don't need to do that. But the bottom line, though, is that that's not illegal. And if I'm the defense, I want to make sure that point is hammered home to the jury, and I asked for a special instruction, if not a limiting instruction, to the judge saying they can't argue or imply that in any way that that's illegal, and that it imposed any type of higher burden on George Zimmerman once he confronted Trayvon Martin, because this is what I always find interesting. No matter what ultimately happened about the altercation, the legal issue to me, the only question that has to be answered is who threw the first punch. Mm-hmm. Because the case law, there's case law directly on point that words alone are not sufficient justification to attack somebody. And so even if George Zimmerman did say right to Trayvon Martin, what are you doing here? Trayvon Martin had no legal right to attack George Zimmerman at all. And I asked for an instruction on that. It's not sufficient provocation.
Do you think that's realistic? Do you think the judge is going to limit the state's argument that they can't argue that if George Zimmerman had stayed in the car, then this would not have happened?
Well, I think she will let them, because if she's Judge Nelson and she's not, I've had 2 murder trials in front of her, and she will never rule in defense favor unless there's a case directly on point. But if there is a case directly on point, she will do whatever the law requires. And there is actually a case out of the 4th District that specifically holds that words alone are not sufficient basis, or do not constitute provocation under the self-defense statute, meaning that George Zimmerman couldn't be considered the aggressor in a situation.
But was it words alone, or was it where it's nighttime, he gets out of his car, he follows this kid, this 17-year-old. I mean, all of those things are true.
Right.
Uncontroverted.
And none of them by themselves are illegal.
Okay, but you just said words alone are not sufficient provocation, but it wasn't just words alone. There were circumstances surrounding it.
But again, you have to. He's getting out of his car in the neighborhood he lives in. He sees someone strange in the neighborhood he lives in. He walks up to somebody. There's no different than me walk up to somebody who I see arguing with their wife or doing something that is suspicious and saying, "Hey, what are you doing?" The chain of events is no different than really what George Zimmerman did. What complicates George Zimmerman's problem, and it's a moral issue to me, is that he was on 9 with talking to the law enforcement. He knew that the law enforcement was on the way. There was no need for him to speed up the process. He could have just waited for it to play out. And that's to me why it's always been. I don't think George Zimmerman is innocent, but I definitely think he's not guilty.
Of even negligent homicide.
I don't think, because to me he can't. It's either one way or the other. Because even if, and this is the thing, let's assume for the minute him walking up to Trayvon Martin and saying something. Let's say that does constitute him provoking this fight. Even then, he was only provoking non-deadly force. He was only provoking fisticuffs, if you will. And in the law.
But that's what he got, Richard. He got fisticuffs and pulled out a gun.
Well, no, that's not what he says happened, and that's not what. There's no evidence. What he says happened is that Trayvon Martin hit him, and that he got himself in a position where he thought he had no escape, which was he's on his back with his head being beat against. And I don't know if it's true. Now I'm saying that's the way that his evidence comes out. And if that's true, the law, the aggressor law, the first aggressor rules holds that even if you started the fight. If the person you start the fight with responds disproportionately and puts you in a position where you're in fear for your life, then your right to defend yourself is restored, and you can pull out, in this instance, your gun and use it. And so I think that if on the defense, I try to even avoid getting that issue. I try to get that the state has to have some evidence that George Zimmerman did more than just use words or approach him. The state has to have some evidence that he actually, scared him with, by threatening him or something more than just saying, hey, what are you doing here? It has to be some type of threat or to do violence to Trayvon Martin. But even if they don't get that, I still think the defense has an extremely strong argument that even if George was wrong in the instance, Trayvon Martin took it to the next level when he was bashing George's head against the ground. And, I understand no one actually saw that, but you have a lot of,
there are injuries to the back of his head.
and then you've got witnesses that say that, hey, I saw something that's exactly consistent with what George Zimmerman said. And at the end of the day, as a defense attorney, what I want to be arguing is, how did George Zimmerman, everybody thinks it's conspiracy, he's lying about it. He didn't make up, he was telling a story within minutes of him killing somebody, and he had never killed somebody before. There's no way that guy was smart enough or is smart enough to have made up this elaborate story to try to cover his tracks, unless what he said was fairly accurate.
Fairly accurate, but he can massage some of the detail because it fit the way he tells it. True to form does fit a classic self-defense sort of argument. It's not as if he doesn't have some kind of exposure to the system because he has an undergrad degree in whatever, criminal justice or something.
Yeah.
So he can massage the details a little bit. Like, for example, if what he really did is walk up and pull his gun on Trayvon, he's not going to say that.
Well,
he's smart enough to do that, right?
And I agree with you. But as me and you both know, though, the state can't even argue that. They would have to have somebody that would support even that circumstantially. They'd have to have something. They'd have to have someone that said, "I saw him holding something. I couldn't tell what it was." They'd have to have something and that's the problem, is that may be true, and that's why I'll never believe that George Zimmerman's innocent. But there's nothing to support that. And when you talk about George Zimmerman, he's got a little bit of background in whatever criminal justice. I got a law degree. I got a master's in criminal justice. If I've never killed a human being, and I know this, I don't, you're right. If I had pulled a gun on him, I'd probably be trying to keep out those major details.
Right.
But at the same time, if I had, with my knowledge and background, if I had pulled a gun out, I wouldn't be screaming for the police at the station. I wouldn't come down the station 3 different times without a lawyer. I wouldn't, do everything he did if I had a modicum of knowledge that, and felt that I did something wrong. I would have, called you right away.
Right. Well, okay. So I'm guessing, or I'm sensing that your position is that the self-defense applies whether it's charged as it is or whether it's charged as negligent homicide, and so therefore he should, quite literally, George Zimmerman should walk out of the courtroom after this.
I do. I believe George Zimmerman should walk out of that courtroom.
Do you think that the state overcharged it? Well, first of all, let's talk about what he's charged with now.
Well, he's charged with second-degree murder, and I do think the state overcharged it, because second-degree murder is they have to show that George Zimmerman did this out of some ill will or hatred or depraved mind towards Trayvon Martin, and I don't see where they have any evidence of that remotely. I think the state did this as leverage, because it gives them, and this is partly Mark O'Mara's fault. If I'm the attorney and I see, a second-degree murder, especially since it wasn't an indictment, it was an information, he could file a motion to dismiss before the arraignment and say, Judge, they don't even have the evidence of this depraved mind. This needs to be produced on manslaughter without even, getting into the facts. And for whatever reason, Mark O'Mara and Don West let that go. But this should be a manslaughter case to begin with. Manslaughter by act.
Well, it was. The original police report
Right.
had it as a manslaughter case, and then we got some revisions
Right.
to the police report.
We got what we call public pressure, and that's what changed it to second-degree murder.
Right. Okay, so then how do you think the state is going to try to prove depraved mind?
Well, I think this is where Dee comes in. This is where I'm kind of, the state really bothers me. I think they're going to use witnesses who everybody knows are not believable, but because a witness can say whatever they want, and that's enough to get them into the door, they can rely on witnesses that even though they inherently know are false. And so you have Dee who makes up, and maybe she's not, I don't necessarily know what she's saying is false, but she makes it sound like George Zimmerman came up there with overly aggressive, and he probably did, so we'll give him that. But then they've got another witness who's changed her story and says, no, they believe that George Zimmerman was on top of Trayvon Martin, with the gun, and that's where you kind of get into this, the issue. And then I think, I don't know, but I think maybe the state thinks they're going to get in some of George Zimmerman's past statements he's made about minorities or things like that, which I don't know how much weight you give to a Spanish guy making fun of a Mexican. You know, I mean, what is what is that? What exactly does that hold? It's a stretch. And the funny thing is, if it was any other judge, I think any other judge would JOA it or reduce it down to a manslaughter charge without much thinking. But this judge does not want to do that.
So then, do you think that the state is going to try to use these previous times that Zimmerman has called on a black male, suspicious in the neighborhood, to try to establish that he was profiling or that he had some kind of
I think they're going to. I think they are. Now, how they're going to do that is, because unfortunately, stereotypes exist for a reason, because sometimes people continue to perpetuate those stereotypes. And so, on one hand, you have the African American community saying you're stereotyping every young black man. But the reality is that George Zimmerman actually had a lot of experience with young black men dressed, like they were about to break into houses in the middle of the night, going through this particular neighborhood. And so I think what the state's roundabout way is that they're going to try to, it's kind of be a subliminal message. Hey, this guy's a racist. The subliminal message, this guy's a racist. And they're going to hope that they can get some jurors to bite on that and to go back to just disliking George Zimmerman. But legally, I'm not buying.
Can you get to depraved mind by acting so recklessly without the profiling and without the racism? Can you get to depraved mind because you acted so recklessly that the action itself shows the depraved mind?
Well, I mean, yeah, you can get that way, but that would have to be like something as outlandish as, just walking down the street firing shots, then your mind's depraved because you're completely acting outside of any rational bounds. But within the context of facts, we know them. I'm just not seeing it, and that's the problem. Is that sure, there's always some example that you could take someone that's probably just acting really negligently and take it to that next level of recklessness or depraved mind, which secondary murder requires. But I'm not seeing it here.
But if you're running around in a neighborhood acting like a vigilante cop and with a gun that you're not supposed to have as a neighborhood watchman, then...
Well, again, this is where, that's where I think that's a lot of emotional argument, because
guess what works with juries?
Well, but the problem is defense attorneys get to argue that, but if I'm a smart defense attorney, I make, every time the state does, I make the judge say that they're only allowed to argue facts. And they are. I mean, me and you both know that. Yeah. And so, if the state doesn't imply in any way that he wasn't supposed to have a gun, I ask for special instruction saying not only is it not illegal for for him to have had a gun, he's got a concealed weapons permit, it's not illegal for a neighborhood watch person to have a gun.
It's not illegal, but it's against their own rules.
But it's not illegal, though, and that's the thing, is was he doing something illegal? And again, maybe you're right, maybe they did have rules, and that goes against to whether or not, and that's more of a civil issue to me, and maybe it goes more of manslaughter, but he wasn't acting in his capacity when he was driving to the store or something when this happened, so he sees, and so what is he supposed to do? Abandon his firearm and his individual capacity as a citizen when he sees something suspicious, so it's asking a lot of somebody, but I'm not disagreeing that he was probably a Keystone Cop wannabe,
Yeah, I think. But okay, so let's go back to the threshold question of why was that suspicious? Why is it suspicious for, in the rain, a 17-year-old kid to walk back from the store with his hoodie up?
Well, I mean, let's be honest, it's suspicious. I mean, when a random person you've never seen, it'd be like if in the middle of the night you're here at your office and you see some guy with a hoodie walking by here, you're going to raise your alarm even though there's a 7-Eleven right there, because you're going to be like, what is that guy doing walking through the hallways back here? He shouldn't be here. So, and again, it's not in a vacuum. It's not like this kid was alone, and it was, George Zimmerman's had reported instances of this that have been confirmed. I mean, they've arrested kids that for actually breaking in, so it's not like his suspicion was in a vacuum. It was a justified suspicion based upon prior experiences. And, you can, listen, I have a nephew that dresses like Trayvon Martin, but I also think my nephew's suspicious. I mean, I don't. Right. So it's hard for me. I can't live in a vacuum is the problem. And that's what I think that's the unfortunate part of this. A lot of people that support the Trayvon Martin aspect of the case expect you to just forget about everything you've ever experienced. When the reality is, you can go to an African American community and you see a guy walking with a hoodie over him in the rain. You're gonna be like, who is that guy? I don't care. So some of the most stereotypical people I know are old black women because they don't trust anybody.
Okay. So then, I sort of gather what I think your answer is going to be, but, so do you think that the reason, okay, let me ask it this way. Do you think if there were another judge that O'Mara and Don West would have done the stand your ground hearing?
Yes.
Yeah.
I do, but why don't they do it? It's obvious they knew Judge Nelson was going to deny the motion, and so there's a lot of things. They know that George Zimmerman probably is not going to be a good witness, and there's probably a likelihood that he would need to testify in a stand your ground hearing. And he may, while he's not required to, he may. And I've always been a believer you have to put your client on the stand, no matter how bad a witness you think they could be. They're never that bad. They're going to have to put him on, so they put him on the stand your ground hearing. Gives Bernie De La Rosa one free go at him, and then all it is to prepare, and then they destroy him the second time around. So I think it was a strategic decision with knowing that the outcome of the motion was a foregone conclusion. And Judge Nelson will never admit that, but the truth is, I don't think you can ever find a serious violent crime where she's made a ruling that was favorable to a defendant. And that's the truth, and I don't know many judges that would, but she's definitely the one that's probably never has.
Do you think that had Zimmerman not been involved with all of that misrepresentation with regard to the bond, that Lester would have seriously entertained the stand your ground hearing?
Yes, I mean Lester would, because Lester's an extremely fair judge, and I think that Lester he takes it more from a legal approach than I think Judge Nelson looks at a lot of, especially serious cases. She's a very empathetic person that looks at it from a victim standpoint, and in her rulings. Whereas I think Lester seems to be very black and white with the law, and I think they would have had a great chance. I think they should have stayed with him in the first place. I don't, I realize that Mark O'Mara had to do it, but.
Why did he have to do it? Because some people would say he had to do the stand your ground. I mean, if what he's doing is CYA, then
yeah, and I agree with you. I think it was a mistake to leave Judge Lester, because even though Judge Lester said what he said, the truth is I think everybody felt that way. I mean, I felt, to me this digital panhandling that they're engaging in, it just rubs me the wrong way as a defense attorney.
Yeah.
I like Mark O'Mara and Don a lot, but I don't. It just rubs me the wrong way, and the fact that they would. Lie about their finances and such a stupid hearing, and because the reason seemed to be that they want to keep the money for themselves, and they felt like they had an entitlement to it. That's what all,
Well, they were talking about going on vacations and going down to the Bahamas with all this money, and
right, it wasn't their money, and
right.
And so, the bottom line to me was this: is that what Judge Lester said in his order was true, and that's even though it maybe could have been worded a little different, it was absolutely true, and I think every person felt that way, probably even Mark O'Mara.
So then, do those misrepresentations with regard to the bond and those lies, so to speak, do those come in this case?
Well, no, because he never testified.
Yeah.
George never testified. What his lawyer puts in motion doesn't count. And Shelley Zimmerman's not going to be called to testify. I mean, she's not. Mark O'Mara's not going to call as a witness. She wasn't there. And if the state tried to call her for anything, they can't try to impeach her because they're the ones calling her. So at the end of the day, I think that's just a little footnote on the whole case. And that's why I would have stayed with Lester in the first place, is because everybody knew that Judge Nelson was the only criminal attorney left at the time. I mean, criminal judge left in the courthouse at the time. That you knew where your case was going to go if you filed a motion to recuse, so why would you even take that chance?
Yeah. So if you are Don West and Mark O'Mara, what kind of jurors are you looking for?
If I would like members of the NRA and Rush Limbaugh fans.
The ones funding your defense?
Well, it's funny because and I think it goes to why they never moved for change of venue. What I want is Seminole County, your prototypical Seminole County resident, which is an affluent, older, white man or female who owns a home. I mean, Seminole County has a 70% home ownership rate. They're 80%, well, they're technically 65% white, but they're 80% white and Hispanic. The majority Republicans. That's what, if I'm looking for a jury, that's it. What they're getting though is they're getting, they're hoping for Fox News, but they're getting MSNBC across the line. I mean, they're getting a lot of minorities, they're getting a lot of younger people, a lot of women, and when you deal with a dead person, the last thing you want is someone that's actually had a child.
A dead kid.
Yeah.
It's hard to get past, period. Yeah. I mean, I've looked through all the evidence, and you hear about, Trayvon gurgling, and you know, and I can't help but think as a juror, as a female juror, what if that were my kid? You know, what if my kid were walking through the neighborhood, just went to the store to get Skittles, and some crazy vigilante, you know, whatever guy comes and shoots him?
Well,
you know, I mean,
well, I agree. There was a woman yesterday during jury selection that said something that kind of struck a chord with me because I don't like guns. I'm not a believer in, you know, like I've, you know, she goes, I couldn't imagine owning a gun, much less shooting a gun at another human being. You know, and that's going to be the problem is you're going to put a lot of these people in that position, you know, and they're going to have a hard time justifying, you know, this whole need to resort to pulling his gun, even though, you know, I think a black and white, cold, calculated look at the evidence says that he's allowed to. You know, emotion's going to play a part in this.
yeah. Did he put himself though? Okay, so does the argument go that because Trayvon, according to Zimmerman's story, knocked him down and put him on the ground so that he did not have an escape route, then that gave Zimmerman the right to self-defense?
It gave him the right to deadly force, right? You know, under the stand your ground law, it's funny because it doesn't even really apply to this case because the legal analysis, if you believe George Zimmerman, and that's the thing, if you believe George Zimmerman, even under the old self-defense law, once George Zimmerman was in a position where he couldn't, there was no escape route, and which is on your back with your head being, you were then allowed to resort to reasonable force. Under the stand your ground law, he would not. He was presumed to have been allowed to stand there anyways if they'd been standing up, but he's saying, well, I never got to that issue of whether or not I had to think about going around. That was on the back. And he's, you know.
Well, but if they were standing up.
When they were talking.
Yeah, and even if they were fighting, standing up, he doesn't have the right to shoot him. Because he has an escape route.
Well, but there's no evidence that he says he shot him when he was standing up.
But I'm just saying that. So that means that the whole crux of his whole defense really is then predicated on them believing that he was on his back with no escape route.
Right.
Because that's the way he walks, even
no
matter who started the fight.
Right, no matter who started, that's exactly right. I mean, no matter how this whole thing played out, whether or not George Zimmerman was wrong at certain points or whether he could have run away at some point, the bottom line is once Trayvon Martin got him into a compromising position, and Trayvon Martin didn't let up, you know, it's one thing to hit somebody and then, you know, and then...
But how long do you have to lay there? Because it was what, a couple minutes max?
You know, here's what I thought is, I mean, how long do you have to get hit in the face before you think, like, oh my God, if I don't do something, he's just going to keep pummeling me until I pass out, and, you know...
Yeah.
I mean, you know, people have heard of things like, you know, I've heard of people getting curbed before when they're passed out, and they, you know, I mean, there's a lot of things that can go through your mind. So that's the problem, is that if you put yourself in George Zimmerman's mind and you're looking up at some guy you don't know, who, for all you know, he is a burglar, he is somebody you don't know he has Skittles, you don't know he has iced tea with him.
Well, and Zimmerman says he went for his gun. I think that's way too convenient in Zimmerman's story for him.
And I agree. I'm not disagreeing with you. Listen, George Zimmerman doesn't. I don't have a lot of sympathy for him. That's, you know, that's for sure. And I don't doubt that. It's like you said earlier. I don't doubt that he's probably like there's certain areas he's like
shading a little bit.
Yeah, a little embellishment never hurt nobody, right?
Well, unless you're, you know, in a bond hearing and they ask you how much money you make and you said none.
Well, he did. His wife said that.
What do you think is going to happen with her case? You think it's going to just die down after this?
Well, she's got probably one of my favorite attorneys in the world.
I love him too. Yeah.
Kelly Sims, and you know, and I've talked to Kelly, and he said they're not making her any offer. So I think that a lot of it will hinge on what happens with George's case. If George wins, I think that they're just going to, you know, cut bait and let it go, or give her something she has to take. If George loses, you know, I think that they give her some type of probation or something and make it. You know, but I've talked to Kelly. You know, the funny thing is you know, Kelly can convince a jury of anything. So I'm not too. I don't think they know what they're up against. They're not, you know, Kelly's on a different level than Don and Mark because, you know, he doesn't try to pretend to be Mr. Super Lawyer even though he is.
He's very humble.
Oh yeah.
And likable and all of those things.
Yeah.
Okay. So let's talk about this Fry hearing, which is where they're discussing whether the expert testimony with regard to who was yelling for help on the 911 tape is admissible. Initially, when the FBI did the analysis, they said that it wasn't of sufficient quality to make a determination. And not only that, it wasn't long enough, and that there were other voices that were superimposed that were causing the problem. So how did we get from that to now an expert for the state apparently saying that Trayvon was yelling for help?
Well, it's junk science. Everybody knows you can find someone to say whatever you want if you search hard enough, and so the thing that boggles me, and I think that when you boil all this voice stuff down, the state is claiming they have two experts that will come in and say you can hear Trayvon Martin say something, but nobody will ever hear what these experts are saying or said. If that makes sense, it's like only people who can ever hear these magical words are these experts who have some special listening skills. Like the one expert, Reich is his last name. He's not claiming he has some computer or something. He's saying he literally can hear these words with his own. That's how
because he's superhero.
Because he's
hearing
right.
them.
He's listened to them thousands of times, and he's been able to isolate because of, to me that's just mind-boggling. He's going to go in and look at a juror and say tell these jurors, you have the capability to do what I'm telling you I'm doing, but you can't do it right now. So trust me, this is what is being said here, and that's just crazy to me. And that's the problem. The fact the state's relying on them, and never mind the fact that Mark O'Mara. I mean, this is a defense attorney's dream. Is going to march in the state's witnesses that they're not calling, say this is ludicrous, and not only is it ludicrous, I would never ever. And it comes down. It's like DNA. You need 13. The CODIS has 13 individual markers in your DNA that you have to have a match. Mm-hmm. And anything less than that is not admissible as a match. And that's what this guy keeps trying to say is he's like, oh, well, I don't have a match. I can only match up 2 seconds even though I need 20 seconds. So what I did was I looped this audio, and he kept using the same audio that was being insufficient by itself. Seconds? But if I loop it up enough, suddenly it becomes, and it's crazy. The whole methodology is crazy. And I have a feeling that Judge Nelson, even she sees that this is crazy. And the fact that they're saying that the trial could be like 2 weeks, I'm thinking that she's indicated she's not letting it in. But I don't know.
But she may be doing the state a favor, honestly, by keeping that out. Because that does sound ridiculous. And the state attorney loses credibility when they try crap like that.
Yeah, that's a good point. I agree with you.
So I think she may be doing the state a favor, which is why she may do it.
Yeah, especially after listening to that. It's crazy listening to this guy. And then you see the defense experts. They were well dressed, the one guy is just like, this is fantasy, what they're talking about. I mean, it wasn't like he was even trying to pretend like, no, this is nothing.
It's ridiculous.
Yeah.
Okay. So then, if you're Don West and Mark O'Mara, what does your opening statement look like? Or sound like?
I think you say an unfortunate situation. It's an unfortunate situation that was escalated because of some bad decisions, but nothing illegal on and that you had a kid who took it to a different level and put a person in a position that he had to do the last thing anybody would ever want to do, which is kill another human being. And so I think there's a lot of empathy and stuff. But if I'm Mark O'Mara, the one thing I'm harping on is that at the end of the day there'll be no evidence to contradict George Zimmerman. And there'll be no law that says that whatever, even though what he did was wrong, it wasn't illegal, which is the standard that the jury has to find. And that's what I'm hammering home the whole time, because every one of these jurors that we've heard in jury selection has said the same thing. He went over there when he wasn't supposed to, when he should have stayed in his car. And, it's true. Woulda, shoulda, coulda, none of this would have happened, but none of it was illegal. And that's, if I'm Mark O'Mara, that's what I keep harping on, because that's the message that has to be conveyed to this whole thing, is that no matter how unfortunate it is, that's like for a civil court to decide, not in here.
And so what do you think the state's opening should look like? I don't want you to predict what they're going to do, because I'm afraid.
Well, they're going to pay him out to be, like you said, a vigilante. I think they're going to apply as a racist, that, they're going to use strong language like Ben Crump's been doing, like, profile them and stalked him and all these things, which, these things that I think that are just very colorful language, meant to play to the jurors' passions, and emotions of how they view the case. And because that's what you look at this unemotionally, I think it's not guilty. You start looking at it emotionally, and suddenly, it's why is this person dead? Whose fault is it? And that answer is always going to point back to George Zimmerman.
But that's always a problem for a defense attorney. It's always a problem that the jury first understands and attaches to the emotional argument, and you have to really pull them out of that.
And I agree. I think that the difference here, though, is that Trayvon Martin isn't just some picture of a black kid that they're going to see in a trial one time, you know, during when the medical examiner testifies. Trayvon Martin's already, you know, been personified to them on TV. It's been, you know, he's become a human already, you know, because of all this exposure that's been focused on him. So these people are going in there more with a kinship, I guess, of Trayvon Martin than we do in our normal murder cases, where it's, you know, do you recognize this person? Yes, that's my son. He's dead. You know, and the jurors are like, oh, that sucks, but they're not really having a lot of emotional attachment yet. You know?
You know, I think that the state should go in and I think it's a mistake for them to go in like that high emotion and immediately bring the race into it and all of that.
Right.
I think they should do it as a much softer sell than that. And I think they should just go in and say, listen, here's the fact. The fact is that if George Zimmerman stayed in his car that night and did not follow Trayvon Martin would still be alive. And Trayvon Martin was afraid. He had a right to be afraid. He was a 17-year-old kid with Skittles and iced tea, and some guy was, you know, following him around the neighborhood. And bottom line is, you know, you'll hear a lot of talk about, you know, distinctions and, you know, trying to split hairs and all of that stuff. But the bottom line is, we know who shot Trayvon, and that was George Zimmerman. Period.
And you know, I mean, I agree with you that I don't know if Bernie De La Rosa is capable of doing that.
I know he's not.
You know, someone asked me the other day what I think of him, and he reminds me a lot of Jeff Ashton. In small doses, he's kind of amusing, but in large doses, he's just extremely abrasive, and I don't think he's capable of controlling his emotions to do that.
Yeah.
You know, and even if he does, I think the problem is, because I guess he's got like a New York, New Jersey, you know, accent, or, you know, even when I think he's trying to be like more subtle, he comes across as a bombastic, you know, lawyer.
Yeah.
And so it's going to be tough for him, unless maybe somebody else will do the opening for them.
Well, where's Angela Corey in all this?
No, come on, she's a boss. She's a boss lady like you know. She doesn't have to show up to work on Fridays.
Right. All right, so bottom line, what do you think? Guilty or not guilty?
I think he's guilty of culpable negligence.
I do too.
Yeah.
And she'll max him out. She'll give him 15 years.
No, culpable negligence is misdemeanor.
No.
Yes.
Not culpable. I thought you meant negligent homicide. I didn't listen to you.
That's what always happens in these cases. I think that because the jury doesn't know it's a misdemeanor, I think they see culpable negligence. It feels it's all warm and fuzzy to them. It's everything that, you know, he did. They find him guilty of culpable negligence, and then she sentences him to 60 days in jail, and everybody freaks out, going, "What just happened?"
I hadn't even thought of that, but yeah.
It happened to it happened.
Because even I, trained and having done these cases, I thought negligent homicide when you said culpable negligence.
Well, I don't even know if he'd be. See, I don't think they can argue. I think they can only argue manslaughter by act, not even manslaughter by culpable negligence, because of the way they charged it. Because they're not even saying he was negligent; they're just saying he was borderline intentional. But like this happened in Osceola County, where there was some kid who got in this argument with another kid, and he ended up stabbing him or something in Osceola County, and it was a little clear cut. Like there was 20 witnesses, everybody. And, you know, and he came in there with some bogus story, and the jury came back with culpable negligence, and he, you know, they thought they had really done the appropriate thing, and he walked out, you know, he'd been in jail more than 60 days. And I've seen it happen in a lot of cases. Like you know, it's not uncommon for the jury, because they don't know it's a misdemeanor.
Yeah. That's a win for O'Mara and Don West, that's for sure.
Oh yeah, absolutely.
Well, thanks for coming by, Richard.
No problem.